All right, let's go to State of Utah versus Heber, Pearson, Jeffs. Mr. Jeffs is appearing from the Sevier County Jail. Mr. Scott Burns is present in the courtroom prosecution, and Mr. Steve Burton is appearing by WebEx. The matter's on the calendar for entry of plea. Mr. Burns, what do you anticipate?
Yes, Scott Burns, Paiute County Attorney for the record, Your Honor. Mr. Burton and I have spoken on multiple occasions regarding a resolution in this case. I think we've reached a resolution, but I don't know if Mr. Jeffs has the plea agreement. He has signed it, if he's executed. I don't have a copy of that document.
Judge, I can fill you in. I spoke with Mr. Jeff's wife and was hoping to let him know that I wasn't going to make it in person. I did prepare a statement of defendant in support of guilty plea. I have discussed the specifics of the plea agreement with Mr. Jeffs over the phone, but I have not had a chance to go over the details of the rights that he's giving up. And so I was hoping to ask if there is any way that I would be able to speak with him over the phone, and then I can submit that document. I emailed a copy of it to Mr. Burns last night, so he might be able to access that in his email to make sure that he's on board with that, and I can submit an electronic copy with my electronic signature, and perhaps the court can take Mr. Jeff's verbal affirmation that he's willing to sign it, or let me sign it on his behalf.
What if I ask him about his rights? Would that satisfy you, Mr. Burton?
I think so, Your Honor. Yeah, quite frankly, we could do it that way as well. Just I would want to make sure that he agreed to the facts that I entered into the statement of defendant, so that he understands what facts he's pleading guilty to.
Okay, my only concern is we just displaced, Sevier County is letting us be here as an accommodation, and we just displaced their prosecutors. So I don't want to displace them twice. Can we just do everything orally right now?
Absolutely, Your Honor, and then also potentially I can just submit the statement so that the court has it for its record later this afternoon.
That would be great. All right, so Mr. Jeffs, I don't know what the plea agreement is, but if you enter a plea today, a guilty plea or no contest plea, you will not have a trial. Do you understand that?
Yes.
And if you don't have a trial, you give up constitutional rights you would otherwise have if your case did go to trial or otherwise went forward. I'm going to ask you about those rights to make sure you understand what rights you're waiving. You waive the right to be presumed innocent. You waive the right to remain silent and not testify if you choose to. You waive the right to have a public trial by an impartial jury and speedy trial. You waive the right to cross-examine, ask questions of witnesses against you. You have the right to call witnesses on your own behalf and to require them to be present in court to testify for you. If you choose to testify, you would have that opportunity if your case went to trial. You waive the right to appeal any conviction to a higher court. You waive the right to have a preliminary hearing if you've not already had some. I think we already did that. And also, if you're pleading guilty to a felony, you'd be precluded from possessing a firearm in the future without it being a crime. All of those rights you waive and give up if you go forward today. Are you willing to waive those rights?
I understand that, yes.
So will your plea be voluntary?
Yes.
Are you under the influence of alcohol, drugs, or medication?
No.
Do you understand what's going on in court?
Yes.
Mr. Burton, do you want to ask him any more questions about his rights that he waives?
No, Your Honor, I think we've discussed it sufficiently that he understands.
Mr. Burns, have we covered the rights
I
well
believe
enough?
you have, Your Honor. I think you've made a clear record, and I think the defendant acknowledged that he understands them.
Okay. And you'll still be able to read those rights and sign off on them, Mr. Jeffs. What is the plea agreement in this case?
Your Honor, it's anticipated that the defendant will plead guilty to custodial interference, a third-degree felony, that he will be released from incarceration today, that we would ask the court to order a pre-sentence investigation report. We've agreed that no further jail time, assuming he doesn't have a lengthy record, and my research is that he does not. There'd be no restrictions from him leaving the state of Utah to go back to North Dakota, and we would ask for 36 months. Did we agree to 36 or 18 months, Mr. Burton?
We agreed to 36 with possible early termination if no violations.
Yeah, so 18 months bench probation. The court standard terms, no law violations, report if ordered by court or adult probation and parole, commit no crimes. I just don't have it in front of me, and we really didn't nail it down. So you're going to have to help me supplement the record, Mr. Burton.
That's all exactly correct. The only additional stipulation was that there would be a stipulation to a 402 reduction to a Class A misdemeanor upon successful completion of probation.
That's correct, Your Honor.
Okay, so we are going to do a PSI. Is that what you're saying?
Yes.
But these are recommendations or things
Yeah,
that you've agreed to.
We agreed to. We wanted to put on the record. Mr. Burton asked about a Rule 11 consultation with the court. I told him, in my opinion, I didn't think it was necessary, but I did think it was important to put those terms on the record. And yes, no contact with the minor child without the court's, a court, any court, but specifically Your Honor authorizing that.
All right. The only one question I had, I heard Mr. Burton say the probation would be 36 months, and I heard you say 18.
I think we can go 36 months, but the record should reflect I'm not going to object to early termination.
After 18?
Yes.
Okay. All right. Mr. Jeffs, you heard all of that?
Yes.
And do you agree that if we go that way, you'll come back for sentencing? Or you'll at least appear for sentencing?
Yes.
You understand that that would be the worst thing that you could do is to not show up for sentencing?
Yes.
All right. You understand that a third-degree felony carries a possible sentence of up to 0 to 5 years in prison and a possible fine of up to $5,000 in surcharge and fees?
Yes.
Knowing that those are possibilities, are you willing to go forward and enter your plea today?
Yes.
Okay, the charge against you is custodial interference.
I do have a citation if the court needs that.
Yeah, why don't you give us the elements, Mr.
So it's under code section 76-5-303 subsection 3, parentheses C. And the elements are that on or about August 5th, 2022 in Piute County, during a period of time when another individual was entitled to visitation or custody of the child, the defendant withheld the child from the individual who is entitled to that visitation with the intent to interfere with the visitation. Additionally, during the course of that custodial interference, the defendant removed the child from the state.
You okay with that statement of facts, Mr. Burns?
I am, Your Honor.
Mr. Jeffs, do you understand the charge?
Yes.
As to that charge, what is your plea?
Guilty.
We kind of got a factual basis there. Do you want to elaborate, Mr. Burns?
Yeah, I'll try and keep it brief. It's fairly complicated, but Your Honor, the mother of the child is Rose Jeffs. Heber Jeffs is her brother. Rose was going through familial problems with her husband, Dwayne, D-O-W-A-Y-N-E, Dwayne Barlow. And she removed 6 of her children. She moved to Cache County to try and make a go of it. Her husband, Mr. Barlow, wasn't around, wasn't involved. They placed this child, this 6 to 9 month old child, in the care and custody of her brother, Heber, and his wife, Sarah. I think she's in court today. And they raised this child. There are some conflictions with respect to a conflict, how often Rose visited. Dwayne Barlow never. And so they raised this child from the age of 6 months, 9 months, until she was almost 10. During the last 2 or 3 years, I think it's uncontroverted that Rose got her life together, raising these children, but was an apostate from the FLDS church. She wasn't part of it. Mr. Jeffs is, and there was a divergence of how this child should be raised. Things changed in recent activities within the FLDS church, and people going to different places, North Dakota in particular. And so she wanted to see her child. She'd been seeing her child, who's now 10. She came to Paiute County to see her child. Mr. Jeffs said, no, things have changed. You can't. So she sought assistance from the Paiute County Sheriff's Office. There was some discussion that she needed more, birth certificate, perhaps a court order. So why Washington County, I don't know. There was some nexus there. But Judge Walton ordered a pickup order, and that law enforcement could use whatever force necessary to go get this child and deliver her to her mother. A case that should have been resolved given sympathies for raising this child, the defendant and Miss Sarah Jeffs, but they didn't do that. He took off. And so for a month or more, law enforcement texted him, law enforcement emailed him. We reached out through family members, just bring her back, and this can be a custody case. This could be something that Your Honor, could hear the facts on both sides and make a decision. But her mom, Rose, wanted her daughter back. And she had FaceTime and contact and visited her, but these folks had essentially raised her. And so there we were. But Mr. Jeffs took off and nobody could find him. And he knew we were looking for him. And we had the FBI, we had the U.S. Marshal Service, we had the Attorney General's office, Investigator Ed Spann, and we couldn't find him. The sheriff finally found him through his investigations in a small town in North Dakota. The concerning thing to me, and I know that it's the word of Rose Jeffs, is when she called me and said that he had told her, I'm not giving her back, and if you want to come try and find her, okay, but you better bring law enforcement with you. And to me, that was the most disconcerting aspect of this, is why is he taking this child? Why has he refused to allow a court to weigh these equities? And he didn't. And so that's why he was charged. He was found in North Dakota. He was arrested on no bail warrant. He was brought back. The child is now back with her mother and natural sibling, by all accounts doing very well. I speak to the mother weekly and get updates. And so those are the facts of this case, Your Honor. And so I think the elements as read by Mr. Burton, who, by the way, has done a great job. So those are the facts, Judge.
All right. Mr. Burton, do you accept those facts?
Judge, to the extent that Mr. Burns said that some of those facts are controverted, I think as far as a factual basis for this case, essentially the facts are that Heber and his wife did raise the child as one of their own children until she was 10 years old. And however, they didn't do anything officially to change custody or anything with the courts. And so at the time that the mother, who had legal custody of the child still technically, asked for the child back, I don't think that there was at that time anything legally that Heber and Sarah had to refuse that, giving the child back to Rose. It was only the child's wish that she didn't want to leave her family that she was with at the time. So because he didn't have, legal grounds at that point, or a court order or anything like that, that's why he's entering a guilty plea, because he refused to return the custody of the child at that time.
Mr. Jeffs, is that true?
Yes.
All right, the court finds that there are facts to support the guilty plea. So, Mr. Jeffs, you do stand convicted of the crime of custodial interference, a third-degree felony. That's an amended charge. We will have sentencing in the case. The clerk could help me out. When's the next time after 6 weeks that I'm in Paiute County? While they're looking that up, Mr. Jeffs, before you're authorized to be released from jail today, but I want you to, as soon as you walk out of the jail, walk across the hall to adult probation and parole and start the process of doing a pre-sentence investigation. They'll get some information from you, they'll get some, and then they'll look into your background, and they will make a recommendation as to what your sentence should be. So you ought to be cooperative with them, or else that would not be in your favor if you're not. So that's the court order before you leave the building. They're in the same building as the jail. So you can walk across the hall and start that process. And then the attorneys have made a record as to what their recommendations will be, but it will be up to adult probation and parole to make a recommendation. So we will have sentencing in Paiute County. I'll give you the date and time in just a minute.
Your Honor,
Yes,
I believe that date will be June the 12th.
June 12th?
That's what my calendar shows.
Okay, June 12th at 10 a.m. sentencing. Any questions, Mr. Jeffs?
No.
All right, Mr. Burton, any questions?
Judge, I sincerely appreciate the court's accommodation, and I apologize for not being there. I will be there on June 12th at 10.
All right, did we cover everything, Mr. Burns?
We have, Your Honor, and thank you
All right.
for accommodating our little county.
Thank you, and
Appreciate it.
I'm sure that the lawyers who practice here are just fine with that.
Okay.
If they're not, they'll let you know.
Thank you, Mr. Jude.
I'd hope that he was appearing as a defense counsel today. He'd change sides.
What's that?
I'd hope he'd appear as a defense counsel. You're changing sides.
I've been there.
All right, we'll take the next case from the jail.